New reporting tonight on what's going on inside of Donald Trump's world as a deadline to put up $500 million is fast approaching. Panic mode, I'm told, is setting in. Trump now has less than a week to secure that bond, and he had been counting on the insurance company that helped put up the $91 million to cover the E. Jean Carroll judgment, that bond, to come in. But the insurance giant there informed his attorneys in the last several days that that option was not going to be on the table. His team has been weighing other options here, like seeking out wealthy supporters or weighing which of his assets could be sold and fast. I'm told that Trump himself has become increasingly concerned about the optics that March 25th deadline could bring, given he is someone who has long tied his identity to his wealth, and he could find himself confronting a real financial crisis in just a matter of days.
What's up, guys? Adam is back, so what just happened? A major bonding company told Trump he'd need $1 billion in liquid assets to secure a bond for his $454 million civil fraud judgment. His own lawyers went back to court and admitted he simply cannot provide it. Not won't, cannot. For a man who built his entire brand on being a billionaire, his own legal team just told a federal judge he doesn't have the cash.
Former President Donald Trump is facing a potential financial crisis right now. A judge ordered him to post a $464 million bond after finding him liable for inflating the value of his properties to get favorable loans. But Trump's lawyers say he doesn't have the cash, and all the insurance companies they've asked for help have rejected them and won't take his properties as collateral. If Trump doesn't find the money, New York officials can ask the court to seize his properties.
Let that land. The man who built an entire political identity around being a billionaire, a financial genius, a master of the deal, had to send his own legal team into a courtroom to formally admit that he does not have access to enough liquid wealth to satisfy what a bonding company requires. This is not a political opponent making a claim. This is not a journalist drawing inferences from incomplete data. This is Trump's own lawyers in formal court filings telling an appellate court that their client cannot access sufficient liquid assets.
Donald Trump's lawyers say he's been unable to obtain a bond for the $454 million he owes as part of a civil fraud judgment against him, his eldest sons and his company. He's asking a New York State appeals court to pause the judgment against him while he appeals. Well, let's cross live now to New York and speak to our North America correspondent, Neda Tawfik, who is there for us. Neda, what exactly is this all about?
Yeah, well, Miriam, when Donald Trump was ordered to pay these massive amounts in 2 consecutive civil judgments, many questioned if he had the cash to do it. Now, earlier this month, he did post a $91.6 million bond in the E. Jean Carroll defamation case. But as you said there, today his lawyers have said he's been unable to obtain a bond in the much larger civil business fraud judgment against him. Now, just for the viewers to understand, a bond company basically takes on the responsibility for any payout if a defendant loses on appeal and is unable to pay.
The bond fight has done something that no investigation, no financial disclosure, no media expose has ever been able to do. It has forced Trump to document his own financial limitations in a sworn legal proceeding. And what that documentation reveals is a chasm between the public projection and the private reality. A gap so wide that a bonding company looked at his claimed wealth and said, "We need $1 billion in cash equivalent collateral to feel secure." And Trump looked at that requirement and said, "I cannot meet it."
And according to Donald Trump's lawyers, getting a bond has been a practical impossibility for them. They say they've reached out to 30 companies, that very few will even consider giving him a bond that large at $454 million, and that others won't accept his real estate as collateral. They'll only accept cash or stocks. So he is asking the New York State Appeals Court to pause the judgment against him while he appeals. Now, if he's not granted that pause, and if he truly doesn't have the cash to secure that bond, well then, Miriam, the Attorney General, Letitia James, could ask a judge to start seizing his assets.
Now let me take you inside the actual court record, because the details are staggering. A judge named Arthur Engoron presided over a full bench trial. Not a motion hearing, not a summary judgment proceeding, a full trial with witnesses, evidence, cross-examination. And at the end of that trial, Engoron issued a formal published opinion finding persistent business fraud. He found that Trump had wildly overstated the value of his properties. Mar-a-Lago, Trump Tower, his golf courses, all of it. The judge found a pattern so extensive, so deliberate, that he used the phrase shock the conscience in his written opinion. The financial penalty was massive, approximately $355 million plus interest. By the time all the calculations were done, the total judgment reached roughly $454 million, and that judgment is accruing interest every single day, $87,000 per day. That is not a typo. $87,000 added to Trump's legal debt every 24 hours while the appeal works its way through the courts. But the judgment itself is only half the story. The other half is what happens when someone refuses to pay or cannot pay, and that is where Letitia James, the New York Attorney General, comes in. James has something that Trump has never really faced before. A formal, documented, step-by-step enforcement roadmap that treats him exactly like any other debtor who owes $454 million and cannot or will not pay. Let me walk you through that roadmap. Step 1 is registering the judgment with county clerks. James has already done this. She registered the judgment in Westchester County, which specifically targets Trump National Golf Club Westchester and the Seven Springs Estate. Those properties now have a formal public record of the debt obligation attached to them. Step 2 is obtaining court orders for liens on identified properties. This creates a legal encumbrance that prevents Trump from selling or refinancing those properties without satisfying the judgment obligation. The lien authority is already formally available to James. She does not need to ask permission again. Step 3 is obtaining writs that allow sheriffs to seize assets and bank accounts. This is the point where the enforcement moves from paperwork to action, where accounts get frozen, where assets get physically taken, where the reality of civil enforcement becomes impossible to ignore. Step 4 is moving to sell or foreclose on properties to satisfy the outstanding judgment. This is the endgame, the point where golf courses, estates, and yes, skyscrapers get sold at auction to pay off what is owed. And here is where the story gets truly dramatic. James sat down with ABC News for an interview. She looked into the camera and explicitly said that if Trump lacks the resources to satisfy the judgment, she will pursue enforcement actions and ask the judge to seize his assets. Then she specifically mentioned skyscrapers, not golf courses, not estates. Skyscrapers. The iconic Trump commercial properties that define his public image as a New York real estate mogul. Think about what that means. The Attorney General of New York, in a broadcast interview, told the world that she is prepared to seize Trump Tower if that is what it takes to collect the judgment. That is not a threat. That is a formal statement of enforcement intention from the highest law enforcement officer in the state. Now, let me take you back to the bond fight, because that is where the financial reality exposure happened. The appellate court gave Trump a temporary accommodation. They said collection would be paused if he posted a reduced bond of $175 million within 10 days. That was a significant reduction from the full $454 million, a break that many people interpreted as a victory for Trump. But here is what most people missed. To get that bond, Trump had to go to bonding companies. Those companies looked at his financial situation and told his lawyers what they would require. And what they required was $1 billion in cash equivalent collateral. That is more than double the judgment amount, more than twice what he actually owes. Because bonding companies understand something that Trump's public image tries to hide. Real estate is not cash. Properties are not liquid assets. You cannot pay a $454 million judgment with Mar-a-Lago. You cannot hand over a golf course to satisfy a court order. You need actual money, actual liquid assets, cash in the bank. And bonding companies determined that to secure the bond, they needed collateral far beyond what Trump had admitted to having. Trump's lawyers went back to court and formally told the appellate court that he could not secure the bond under those terms. Could not. That word in a legal filing from his own lawyers is the most damaging admission in the entire saga. Because it comes from his own team. It is not opposition research. It is not media speculation. It is Trump's representatives telling a court that their client does not have access to the level of liquid assets that a bonding company requires. The appellate court ultimately allowed the reduced bond. But the damage was done, the admission was on the record, and everyone who pays attention to these things, donors, allies, political opponents, the media, the public, saw exactly what Trump's lawyers said. Let me talk about what this means for the billionaire myth. Because that myth is not just about ego, it is the foundation of Trump's political identity. He is the successful businessman who knows how to make deals, the wealthy outsider who cannot be bought because he already has more money than anyone, the financial genius who built an empire. That myth took a direct hit from the bond fight. Because a real billionaire, a genuinely liquid billionaire, does not struggle to secure a bond for a judgment that is a fraction of his claimed net worth. A real billionaire does not need a bonding company to require collateral double the judgment amount. A real billionaire does not have his lawyers tell a court that he cannot meet the bonding company's requirements. What the bond fight revealed is the difference between net worth and liquid wealth. Trump's net worth, whatever it actually is tied up in real estate. And real estate is the most illiquid asset class there is. You cannot convert a skyscraper to cash in a week. You cannot sell a golf course to pay a court judgment by Friday. The properties that make Trump look wealthy on paper are the same properties that make him cash poor when a judgment comes due. This is not speculation. This is basic finance. Bonding companies know it. The court knows it. And now, thanks to Trump's own lawyers, the public record knows it. Now let me walk you through the daily accrual math, because this is where the pressure really builds. $87,000 per day. That is what the interest adds to the judgment every single 24-hour period. While the appeal proceeds, while the lawyers argue, while the court considers the case, the debt grows. 1 week of appeal adds more than $600,000. 1 month adds more than $2.5 million. If the appeal takes a year, which appeals often do, the judgment grows by more than $31 million before a single word of the final ruling is written. This is the mechanism that forces resolution. Trump cannot wait forever. Every day he waits, the obligation gets larger. Every day the appeal continues, the ultimate payment grows. And if he loses the appeal, he owes the original judgment plus all that accumulated interest. The appellate court's temporary accommodation paused collection. It did not pause accrual. The interest keeps running. The debt keeps growing. The pressure keeps building. Let me tell you about what this means for Trump's political and legal operations. Because those operations run on money. Campaigns cost money. Legal defenses cost money. Lots of money. And the bond fight liquidity revelation has done something that no attack ad could ever accomplish. It has publicly documented that Trump's access to liquid cash is not what his public image suggests. Donors notice things like this. Big donors, the ones who write million-dollar checks, do not want to throw their money into a black hole. They want to back a winner. They want to support someone who has the resources to fight and win. When they see that Trump's own lawyers told a court he could not secure a bond without collateral far beyond his admitted liquidity, they start asking questions. Questions that Trump does not want to answer. Political allies notice, too. The same allies who have stood by Trump through 2 impeachments, through countless investigations, through everything the political system has thrown at him. They start to wonder whether the financial foundation is as solid as it appears. They start to think about their own political futures and whether tying themselves to a man whose properties might be seized by the state is a smart long-term strategy. The legal defense operation is even more directly affected. Trump is facing multiple criminal prosecutions. Each one requires a legal team. Each legal team requires payment. Those payments are due regardless of what is happening with the civil judgment. And if the civil judgment ultimately forces asset seizures or account freezes, the money to pay criminal defense lawyers could become much harder to access. Now let me talk about the untouchable billionaire myth. This is the political identity claim that has protected Trump for years. The idea that he is above the normal rules because he has the resources to fight any legal battle indefinitely. The bond fight and the enforcement roadmap together destroy that claim. The enforcement roadmap treats Trump like any other debtor. The same registration process, the same lien authority, the same writs, the same foreclosure mechanism. The New York Attorney General has explicitly stated that she will pursue the same enforcement actions against Trump that she would pursue against anyone else who owes $454 million and cannot pay. That is the killer, not the judgment amount, not the interest accrual, the parity. The fact that the legal system is applying the same rules to Trump that it applies to every other citizen. The fact that a judge has found him liable for fraud and the enforcement machinery is now moving exactly as it would move against anyone else. Trump has spent years claiming that he is treated unfairly, that the system is rigged against him, that prosecutors and judges are biased. But the enforcement roadmap is not biased. It is mechanical. It is procedural. It is the same set of steps that would apply to any defendant who lost a $454 million fraud judgment, and that is what makes it so damaging to his political identity. Because the one thing Trump cannot claim is that the enforcement process is treating him differently. It is treating him exactly the same. And being treated exactly the same, for someone who has built an entire political career on being above the rules, is devastating. Let me walk you through what to watch for as this story continues to develop. Because the next several months are going to determine whether the enforcement trajectory reaches its ultimate conclusion. First, watch the appellate proceedings. The appeal of the Engoron ruling is Trump's best chance to reduce or eliminate the judgment. If the appellate court upholds the fraud findings and the judgment amount, the enforcement roadmap accelerates. If the appellate court modifies the judgment, either by reducing the amount or reversing some of the findings, the enforcement trajectory changes. The appeal is the pivot point. Everything turns on what the appellate court decides. Second, watch the daily accrual. $87,000 per day adds up quickly. As the total grows, the pressure on Trump to find a resolution, any resolution, increases. At some point, the judgment becomes so large that even a successful appeal on the merits might not be enough, because the interest accrued during the appeal process could be upheld even if the original judgment is modified. Third, watch James's enforcement activity. She has already registered the judgment in Westchester County. The next steps are liens, writs, and foreclosure proceedings. Each of those steps will generate court filings. Each filing will be public. Each public document will show the enforcement machinery grinding forward. When James files for a writ allowing sheriffs to seize accounts, you will know the endgame has begun. Fourth, watch the donor and ally signals. When major donors start pulling back, you will hear about it. When political allies start distancing themselves, you will see it in their public statements and their private maneuvering. The bond fight liquidity revelation is the kind of information that changes behavior behind closed doors long before it changes public positions. Let me bring this all together with what the documented record actually shows. The Engoron judgment is a formal, published judicial opinion finding persistent business fraud. The Westchester County registration is a completed enforcement step targeting specific properties. Trump's own lawyers told the appellate court that bonding companies required $1 billion in cash-equivalent collateral, more than Trump's admitted liquidity. Letitia James told ABC News explicitly that she will seize assets, including skyscrapers, if Trump cannot satisfy the judgment. The enforcement roadmap from registration to liens to writs to foreclosure is formally documented and publicly available. The interest accrues at $87,000 per day throughout the appeal process. Every single one of these elements is documented. Every single one is sourced to court records, official statements, or major news organizations. Every single one is part of the formal institutional record. The story of the judge seizing Trump accounts is not speculation. It is not prediction. It is a description of enforcement mechanisms that are already in motion, already documented, already publicly acknowledged by the relevant officials. The question is not whether the enforcement machinery exists. It does. The question is not whether James has stated her intention to use it. She has. The question is not whether Trump's own lawyers have documented his liquidity constraints. They have. The question is, what happens when the appeal is resolved? If Trump loses, the enforcement trajectory resumes from steps already completed. The liens are already available. The writs can be requested immediately. The foreclosure process can begin within days. The accounts can be frozen. The properties can be seized. The skyscrapers that define Trump's public image can be sold at auction to satisfy the judgment. That is not hyperbole. That is the civil enforcement system working exactly as designed. The same system that would apply to any other debtor who owes $454 million and cannot pay. The billionaire myth has taken a hit from which it may never recover. Not because of what opponents have said, not because of what journalists have written, but because of what Trump's own lawyers were forced to tell a court, because of what a bonding company required before they would issue a bond, because of what the New York Attorney General has publicly stated she will do. The myth was always partly fiction. Now the fiction is documented. The gap between projection and reality is a matter of court record, and the enforcement machinery is moving. This is the moment when the legal system treats a former president exactly like any other citizen, when the rules apply, when the judgments are enforced, when the properties can be seized, when the accounts can be frozen. This is the moment that changes everything. Drop a comment below and tell me what you think. Does the enforcement roadmap lead to actual asset seizures, including the skyscrapers that James explicitly mentioned? Or does the appeal succeed in modifying or reversing the Engoron fraud findings, containing the damage before the most dramatic enforcement steps are taken? I want to hear from you. I will see you in the next video.